What is an adult guardianship? So one of the things that unfortunately a lot of people don't plan for, or don't like to think about, is as they get older, them becoming incapacitated, or you know Alzheimer's, dementia, Parkinson's, some sort of illness, disease, accident, something that renders them unable to function. Right? When that becomes the case, when somebody is unable to, you know, manage their own life without proper planning in place, they have to do what's called a guardianship, or some states might call it a conservatorship. Now, hopefully, you've done planning, you have a power of attorney, you have a healthcare document, healthcare power of attorney, maybe you have a living will, some other stuff in, maybe you did a trust and all the assets have been placed into the trust. When you do that, typically, generally, hopefully you'll be able to avoid the guardianship. But if not, then you're going to have to do a guardianship for an adult. Now, there's a couple things that happen, and there's a couple different types of guardianships. The first one is guardian of the property. Now, when we say property, we don't just mean real estate. We mean assets. We mean money, bank accounts, life insurance, investment policies. Anything that a person owns would be considered their property. So if a person is maybe they're able to function a little bit, but for a variety of reasons, they themselves don't trust themselves with money, or maybe a family member or a loved one is afraid of them getting taken advantage of, or not managing their money in a wise way. Now, this just can't be because, hey, Steve's never been good with money, I'm afraid he's going to spend it. There has to be a little bit more to it than, hey, I just don't think they're as good with money as they should be. But if there is a situation where a person is not able to manage the money, then you'd have to do a guardianship of the property. And what happens is there would be a court process, a judge is going to be involved, and the judge essentially is going to sign some documents that removes the ability for that person, we would call them a ward in that case, to be able to manage their own money. And there's going to be some things that are set in place. For example, there's going to be a guardianship account, and all of a person's money is going to be put into that guardianship account. It's a restricted account, meaning that that person cannot just go take money out of it and spend it however he or she needs. Whenever money has to be spent, an attorney who represents the guardian is going to have to go into court. They're going to have to ask the judge, hey, my client needs to spend money on, rent, or whatever the case may be. The judge will sign an order, and then that restricted bank account, whoever's managing it, will give a check to the ward, to the person, or more likely pay the bills directly. As you can imagine, it's an expensive, very tedious process. So, again, this is used sort of in extreme circumstances. If everything's been set up properly, a power of attorney, healthcare documents, then this might not be necessary. But this is the first one that you might see, is a guardian of the property, where you're just having a court say that this person cannot manage their money, and there needs to be a guardianship account set up so that the court has some oversight, basically to protect him or herself from losing that money. The more serious is called a guardianship of the person, and this is typically in two instances. Number one, they were in an accident and they're incapacitated. Maybe they're even in a coma, or they're just physically unable to do anything, mentally not competent, they're just completely incompetent. And so the court needs to name somebody to be able to manage this person's life, manage their affairs, because they're just unable to do so. Or number two, they might be suffering from Alzheimer's, dementia, something like that, and they just, again, they're unable to, they might be fine physically, they can get around, but mentally they're just not there, and they're not able to manage their life or manage their affairs. When that's the case, it's a little bit more complex. There'll usually be a team of doctors. The amount in Florida, it's typically 3 doctors are going to evaluate this person to give their stamp of approval, saying, yeah, this person is a legal guardian needs to be named on their behalf. They can't operate themselves. You go to court, and the court is basically going to strip them of their legal rights. Now, it might not be all their legal rights. It really depends on the circumstances and their lack of capacity, but most likely they're going to say you can't drive, you can't vote. There's a whole lot of things that, basically you're just not going to be able to do anymore. And again, this becomes very difficult for the families because this person has to be brought into court, declared incompetent, and now somebody's got to become the guardian of this person. And a lot of times there might not be anybody who's able to do it or willing to do it. And if you did not plan for this, if you did not put this down in your will or your trust, then the court's going to pick somebody, and they might pick somebody that you didn't really want to be your guardian. Or if no one comes forward, the court's going to name a court-appointed guardian, which again is someone you don't know, who's taking care of you. They're getting paid out of your money. And again, so this is something that most people don't think about, right? It's not something, especially when you're young, you're not thinking about, I might need a guardian. But when you start doing your estate plan, you need to make sure that you're asking these questions. Well, what happens if I become incapacitated? Who's going to take care of me? I want to make sure that I name somebody who can do that. I don't want to have a guardianship because, that's going to eat into the majority of my money, the fees, the expenses, everything like that. So make sure that planning for, we would call this incapacity planning. Make sure this is planned for. Make sure this is in your written documents so that hopefully the day never comes where you need it, but it's in place if and when that day comes, and you don't have to go through a whole process of an adult guardianship, either as the guardian of the property or the full guardian of the person.